At this time, we're going to invite up Jeff Van Treese. Mr. Van Treese is an attorney from Michigan. He fills my role for Michigan. He used to be a city attorney in the state of Michigan, and so he understands the NIMBYism and reasonable accommodation and zoning issue from both sides of the table. I recently had the pleasure of traveling to DC to do some advocacy work with the Department of Justice Civil Rights Division with Jeff, and the comments and remarks that he made were very impactful and thoughtful and have really kind of changed how I look at reasonable accommodation, fair housing. And so if we could give a round of applause for Jeff, and I hope that you guys found this as interesting as I did.
So thanks, everybody. My name is Jeff Van Treese, and I see I've only got the good students left, so that's perfect. As Butch said, I've run the Michigan Association of Recovery Residences for about 6 years, and also on the NAR board of directors. But today, I'm going to talk to you folks about a different venue than the appellate court. I want to go try somebody in federal court and sue them, and I need to get Steve Poland and a couple $100,000 to go into federal court. Before that ever happens, there's a process in front of whatever the local governmental zoning board or municipality is. And unlike Michigan, my understanding is that here in Colorado, Butch has got everybody around his little finger. And so all the zoning people, all you need to do is call Butch and he'll get it worked out for you. I say that a little bit facetiously, but it's absolutely true. You need to call CARR first. If you don't call CARR first, you're making a mistake. And the reason is because CARR's been down the road and that route before, and will have known the actors, the municipal city administrators, the city attorneys, the local people in town that are going to be making the decisions on a reasonable accommodation request. So having said that, I want to help you folks prepare for a reasonable accommodation if that doesn't work. If you're faced with a situation where you just have people on the board or the ZBA saying, well, I'm not going to give you folks a reasonable accommodation. And I've, being in a slightly more litigious state, Michigan, I've heard everything from they need to be out on a farm somewhere to I don't want those kind of people around me. It's an educational process. You have to explain to the average person that what's happening in recovery is the exact opposite of what happens in the addiction process. This isn't somebody where you got 6 people who are addicted to drugs using drugs in a recovery residence. In fact, the only recovery resident, or the only residence usually on most blocks where there are not any illegal drugs or not people drinking to excess, is going to be a recovery residence. Why? Because we're all in recovery. And there's a huge difference, and people don't get that. So you need to explain that to people. One of the ways that I try to do that is in the context of a reasonable accommodation. Typically, there's a form that needs to be filed with the ZBA or the Board of Appeals or some conditional zoning board approval process. In doing that, you need to do a great job of explaining to them the 2 reasons why you're entitled to a reasonable accommodation under the Federal Fair Housing Act and under the ADA. So there's 2 parts. 2 tests. One is there a financial reason needed for an exception to the zoning ordinance? And the other one, is there a therapeutic reason? The usual context that this is discussed in is a single-family residential zone district. It usually has language that says you can't have more than X, usually in the neighborhood of 3 or 4, unrelated people living in any single-family residence zone district. So that's the request for reasonable accommodation that you'll find yourself in front of almost all the factual circumstances. Having said that, there's some innovative people, municipal lawyers, trying to come up with ways to discriminate against recovery residences that are out east that say, well, if you run a recovery residence, you need to put in a sprinkler system, an automatic, and I don't know if anybody's ever looked at what the cost of a sprinkler system is, but for the usual rented house, the sprinkler system is going to be 20 grand or more. So that just makes it financially not the best situation for recovery residents financially. So my thought was, I'm going to go through a request for reasonable accommodation that I happened to do 2 weeks ago for Building Men for Life. They run about a 12-house, 195-person bed capacity recovery residences in Holland, Michigan. And the, see if I can make this work. Okay, so this is the front page of the application, and this application only exists because Building Men for Life, when I represented them 5-6 years ago, went in front of the city attorney and said, you folks really need to draft a reasonable accommodation ordinance. And so that's why this particular municipality had a reasonable accommodation ordinance. You'll get in front of some municipalities in the hinterlands, in the rural areas, that will look at you and say, what are you talking about? I don't know what a reasonable accommodation is. I don't have any ordinance for that. Take that back to your city attorneys, folks up in the big city. So you can get everywhere from, I don't know what you're talking about, to, yeah, I have an ordinance and here's the procedure for the ordinance. So this is the fourth page, and if anybody wants any of these things, just contact Butch. He's got them on a C drive or whatever you call it. So direct your attention to question 2, which is the recovery house a certified member of an established entity that conducts its own inspections and has its own standards for the benefit of the occupants, e.g. CARR International, NAR, or any equivalent entity having similar requirements for membership? So that was a provision that was installed in the ordinance to show recognition for, we're just not talking about somebody who decided to open up a recovery residence yesterday and is now opening up and running them with no training, no background in it at all. No, these are NAR certified, or in your case, they're CARR certified. And what that means is that CARR has done an inspection on the home to make sure that it meets all of the standards, not only of your local building codes, but also of the NAR standards, which are higher and more specific than the BOCA code, building code. One of the other things that's not particularly, I don't think Colorado has the training available yet, but I think we were looking at doing the training, is there's a 20-hour learning module system training available through NAR that is available to all of the NAR affiliates and any members of the NAR affiliates. It's 20 hours long. It's taught by over 30 different international experts, all of the Dr. John Kellys and the Dr. David Bests of the world and the Dr. Keith Humphreys of the world. You all see them there, along with people who have spent really the better part of the last 10 years trying to look at and research and find what is most effective for the social model of recovery. So that is something that I would encourage you to stress if you ever have the opportunity or ever required to make a reasonable accommodation request, that you stress that this has already been approved by really what is a quasi-governmental entity, CARR, because they're doing the job that is typically done by a governmental agency, which is ensuring the public trust that the operators are held accountable to make sure that their recovery residences are operated under the NAR standards and the NAR Code of Ethics. From a therapeutic point of view, you folks really should spend time on the NAR website, if you haven't already, to look at the research that's available there. Has anybody heard of the Johns Hopkins Medical University study of 2011 in the Journal of Addiction Science, rather? Okay, I got a resounding no. Well, guys, you should take a look at it. And what that did, and I used this as the first bit of research successfully in half a dozen or more requests for reasonable accommodation on behalf of clients in Michigan. Johns Hopkins Medical University in Baltimore, Maryland, did a study in 2009 and 10, along with our NAR affiliate in Pennsylvania, PAR, where they took 300 people who were all inner city Baltimore residents, all men, all of whom had relapsed at least once, and all had a opioid or a heroin dependency. They took the first 100 people and they gave them the typical standard medical model of treatment, which is you're going to spend 60 days in a treatment center, and then on the 61st day, we're going to kick you out the door, pat you on the back, give you a list of NA meetings or AA meetings to go to, and say, sin no more, my child. That doesn't work out that well. The people, of those 100 people, they measured how many people had maintained sobriety 60 days after a successful discharge. The answer was 1 in 20, 5% of the people. That's how many people maintain sobriety unless you give them the additional level of support, the longitudinal level of support, the support that lasts over a period of time. You have to teach these people, me being one of those people, how to live a life without drugs. And it takes a little bit of time. I know I wasn't ready for it, even close to being ready for it, on the day they kicked me out of my treatment center after 90 days. So that's the medical model. That's the old historical baseline of how successful we are in treating and having people recover and maintain recovery. 5%, 120, it's not very good. They took a second group of 100 people. That cohort, they added one thing to, which was here's another 60 days of support, longitudinal support, another 60 days after the treatment had ended. And then they measured that group of people. And that group of people stayed in a recovery residence for another 60 days. Anybody want to take a wild guess as to what the numbers were after an additional 2 months in a recovery center, recovery residence? Went up to 50%, 10 times. If anybody was a doctor or in the medical profession and said, take any disease, diabetes, whatever, said, here's a method where I can show you recovery from your condition 10 times better than what we've been doing as the medical model forever, you think that would get people excited? It gets me excited. The third cohort of 100 people, they added what the second cohort had, which was here's an additional 60 days in a recovery center, and they added to that once a week worth of IOP. The numbers went up to about 2/3. We're doing a study in Michigan in the next 6 to 9 months that's going to substitute peer recovery coaches as opposed to a person conducting an IOP, which is, in my mind, the person that conducts the IOP is somebody that's 25-year-old, freshly scrubbed out of college that doesn't really know what life is, trying to tell me about my recovery. Not that I have any problems with that. Versus, by the way, one of my brothers is a tenured psychology professor, and what he knows about recovery is like that much. That's all they teach you. And he got his PhD from Michigan State. They didn't basically teach him anything about psychology, about recovery rather. So the third group, I think with a peer recovery coach added to that cohort as opposed to an IOP, I don't know what the results are, but I know it worked for me. I had somebody with a functional equivalent of a sixth grade education help me. He was a peer recovery coach. He knew exactly what I was going through, and he assisted me. So I'm 110% behind all things peer related, and I'm 110% behind everything that you folks are doing here to get the job done. So you'll see on page 5, if I've got page 5 up there. No, I don't. You'll see on the last question that I put some language in there about an affordability perspective and a therapeutic perspective, because those are the two tests. I don't know if anybody's done a reasonable accommodation request here in the audience. Raise your hands. Okay, none of you guys do anything. Oh, one. Excellent. Were you successful? Okay, well, you know, it's a lot of it's the little battles, and a lot of it is simply trying to reach a reasonable accommodation with the municipality. For instance, the typical thing is, well, I've got a 5-bedroom, 3-bath, and I want to put 10 people in it. Okay? Because you could put 10 related people in a 5-bedroom, 3-bath, no problem. Unfortunately, a lot of the scientific studies are based upon Oxford House models, which are 6 to 8 people, not 10. And so one of the things that a municipality may say in response to, gee, I need 10, or if I got a 6-bedroom, I need 12, is, no, you don't really need that. You can't show me that you need a financial basis to have that. You can just increase the rates. And your evidence about therapeutic benefit is really related to 6-person, 8-person beds, homes. There is some research being done currently, being done by Dr. Tennis out of the University of Chicago, where he's looking at, is there better outcomes with 10 people than there is with 9? Is there better outcomes with 12 people than there is with 11, et cetera, et cetera? So, and my feeling on this from my own personal observation and experience in living in recovery for 11 years is that, yeah, it's all about contacts. It's all about connections. And so if you've got 10 people to make connections with, that's going to produce 40% more than if you only had 6 people to make connections with. So that's the thing that I try to do. One other suggestion is that when you make your record in front of the ZBA or the city council, you want to do 2 things. You want to give those people on the city council that have a vote the opportunity to understand what happens in a recovery residence, so that they're well equipped and they can vote yes and not have problems when they go down and talk to their neighbors down at the grocery store and say, why'd you let those crazy addicts into my neighborhood? You can say, no, that's not what we're doing. The other aspect that you want to make sure that you pay attention to is you want to make sure that you get a record. Depending upon the jurisdiction and the municipality, they may have everything recorded like they're doing here, and everything that I've sang is being recorded, could be transcribed. Or they could be some smaller organization that has nothing other than a clerk taking notes. So one of the things you might want to consider if you want to be more litigious and adversarial is having a court reporter come to the reasonable accommodation meeting to take notes, to take a transcript of what everybody is saying. Because that'll do two things. One, it'll preserve the record if it needs to be appealed. And secondly, it has an effect of quieting down some of the more obnoxious comments about people need to go live on a farm somewhere type of comments. So that's one of the things you could consider doing. Testimonials and support. Get something from your probation office, get something from the police, get something from some people that are hopefully well-known and respected in the community that have actually been through a recovery residence or know what a recovery residence is. You want to display with pride. I've got my CARR review and inspection. That's basically over and above anything that the city zoning people would be doing. So those are the types of things that I would encourage that you do. This is more just kind of on the fly comments, but there was a comment earlier about LGBTQ inclusion and equity and the proper placement of LGBTQ plus trans people in a recovery residence setting. Michigan actually had that. Building Men for Life had a biological female that wanted to come in and be in the house. And so we did that as a MAR, the Michigan Association of Recovery Residents, said, yeah, we could do that as a pilot program. It's been done 2 more times. Wildly successful, by the way. Wildly successful. Fantastic outcomes. And that's something that can be addressed to Butch, and if Butch doesn't have an answer, what Butch can do is ask the NAR Standards Board for some guidance on that, that's what we did in Michigan a month ago, and I expect to get some guidance from the NAR Standards Board, which again are a bunch of experts on here's how to properly address all the various concerns that people have with transsexual people in a recovery residence. So having said that, I want to play a little tape if I can figure this out. This tape was done at the request of the state of Michigan for the state opioid litigation settlement funding. And the state asked a number of stakeholders to address the various local counties, cities, townships in Michigan that are going to be getting all the opioid response money. So we'll define a family, which is the allowed use, as having X number of unrelated people. No more than X number of unrelated people. And the X is usually 3 or 4 unrelated people. In 1988, the U.S. Supreme Court case, which is cited here in the credits, the U.S. Supreme Court said, no, people that are in recovery, not people that are using, or involved in their active recovery, but people that are in recovery are a protected class under the Americans with Disability Act and are protected under the federal fair housing laws. That requires cities to treat groups of people in recovery that are unrelated as the equivalent of a functional equivalent of a single family for zoning purposes. Accompanying this tape or credits on the tape is a model state ordinance for municipalities dealing with requests for reasonable accommodations. And the request for reasonable accommodation is, under the ADA, please accommodate or waive the provisions regarding limitations on single-family use to allow people that are all in recovery to grow together, to allow people in recovery to reside together so that they can both accommodate the number of people to make it fiscally able to run a recovery residence, and also there are better outcomes. Evidence-based science tells us that. So if anybody has any questions regarding what is detailed in the YouTube channels and in the model state ordinances, I'd invite you to please give me a call. I'm on the NAR board. I am a former Michigan municipal attorney and practice law here in Michigan. And I can be happy to talk to any of your city attorneys and or zoning officials to make sure that you don't have the same fate that there's one township, Dalton Township, that refused to grant a reasonable accommodation based upon stigma-related reasons. And that township had a Department of Justice HUD complaint filed against it, required them to pay the plaintiffs all of their attorneys' fees, to pay the plaintiffs their lost profits, and also required their entire zoning commission, planning commission to sit on an educational session on what is the meaning behind the ADA and the Federal Fair Housing Act as it applies to people with substance use disorders. And I would ask you, do you want to be part of the solution or do you want to be part of the problem? And part of the solution is to bring recovery to people in Michigan. It is evidence-based, it's cheap, it works, it should be funded. That stops the revolving door of people going through treatment centers, falling off the wagon, and then having to go back into the treatment center at a cost that is prohibitively expensive as compared to simply the support necessary and given under the NAR standards. One last comment. One of the things that MAR does, the Michigan Association of Recovery Residences, I view it, MAR's role, which is to certify recovery residences throughout the state of Michigan, is meeting the NAR standards and the NAR Code of Ethics, as really a quasi-governmental function. MAR's been funded by the state of Michigan to do exactly that, which is to bring recovery, to bring quality standards, and to make sure that their code of ethics applied. So I think that's it. If anybody wants to, or if you haven't looked at the Michigan website, I'm kind of half proud of that. We've got our own YouTube channel on it. It's michiganarr.com. There are a number of conversations I have with like Dr. Amy Miracle and Dr. David Best on there. And I just think it's a great way of trying to communicate with our members in Michigan. We also do some trainings in Michigan. I think, I know I've talked to Butch about trying to access the 20-hour training. In addition to that, we also have a state-specific that we did in Michigan just for the Michigan operators on how you deal with Michigan peculiar law and procedures and dealing with their state regulators, et cetera, et cetera. And so that's Butch's next project. He's not aware of that yet, but he's going to be doing something, that'll be probably a year from now. But my guess is that Colorado, just like Michigan, just like Missouri, just like Virginia, will also add something to the national training, which will be, here's how we do it in Colorado. Here's how you need to deal with anything that deals with a reasonable accommodation or something that deals with an eviction. On that topic, I'll also end, I think, my talk this afternoon about evictions. I'm a property lawyer. That's what I'm not a litigator, I'm a property lawyer. And there are a million different ways you can slice the whole unit that's a pie, that's all the ownership rights. And so I know that there is law in other states. I'm not aware of what's in Colorado, and I'm not a Colorado licensed attorney. You need to talk to Dara, I think. Dara on that. Yeah. Call him, and then he'll get you in charge with the Colorado lawyer that knows what she's talking about. But yeah, so that is something. That training, I think, is going to be very important to people here in Colorado. So that's it. Unless anybody has any other questions.
Hello? Okay. Hi.
Hi.
Hi. Thank you for speaking. I have a lot of questions, but I'll just... So I've gone through this with 2 different cities. On my own, I didn't have a lawyer helping me. And so I just have some questions. Because you mentioned that is it common to have an in-person meeting with the head city planner when you're filing for reasonable accommodation? Or... Because both times I just submitted my documents and then got a yes or no or, whatever response.
It varies across the total scope of the different type of municipalities. They can go all the way from, again, we've never heard of what you're talking about, and you'll come and have to ask the city council for approval, to it's just an administrative procedure. All you really need to do is show that you've got a house that meets building code standards and you've got a CARR approval, and then there's some administrative approval process. And I'm aware of that in Michigan. That's exactly what they have in Grand Rapids. You go 100 miles up farther north and they'll look at you and say, what are you talking about? I don't know anything about FHA, federal law. So, yeah.
And then when they give you a response, is it common for them to not explain why they said no? Or because one of the answers I got was we don't find it's a financial hardship, so we'll approve you to have this number, and then I have to lower the number every 3 months until I get to the number they want me at. And when I asked for them to explain that, they wouldn't, and so I'm just kind of confused.
Yeah, that's when you need to get. I've got Steve Poland on my cell phone, on my speed dial. Can I use your phone to follow? Sure, yeah. Actually, I've stolen some letters from him. He writes a great letter, yeah. So I would either do that or I contact Kim Savage. Kim is a lawyer in Los Angeles who's like Steve Poland, but probably 30 years younger and a more vicious bite.
Yeah, because also with this particular city, their laws when I opened there in that city were written favorably. Like they totally supported group homes. There wasn't a limit on the amount of people, or they called it a group home. And then after I opened, they changed the law, and then they reached out and told me that I had to go down to this number when they had approved me for the number I was at. And so it all just seemed really sketch to me.
Yeah, it sounds sketchy enough to me
Yeah.
that if I were a Colorado lawyer, it's like, yeah, I want to talk to you.
Yeah? Oh, okay. Well, I'll reach out. All right. And then also, sorry, is it possible, so if you submit for reasonable accommodation and say we're denied, can you keep resubmitting with new information? Generally. Does that make
That
sense?
depends upon what's written, how it's written, if it's written at all. Some procedures will say there needs to be a set of changed circumstances factually. Some will put on limits like if there's been a decision, you can't make another request for another 6 months or 12 months. Some of them will be completely silent on it, in which case there's nothing stopping you from filing a second and third and fourth request for reasonable accommodation.
Keep bugging them.
Yeah.
I think that was it. That was my last one.
Okay. All right.
Thank you.
You're welcome.
Yes, that is the legal term for how some cities act.
You mentioned the Dalton County, that was the one that had the HUD claim filed against them and had to basically pay like punitive restitution, loss of profit damages. What,
And it's Dalton Township.
Dalton Township?
And the beauty part about that Dalton Township case, and this is how you're going to get impact in the closed session where the city attorney are talking to the city council people saying we're going to get sued. They had to go. The city council and the zoning board of appeals had to go and pay for and attend a class to teach them here's how the federal ADA and the federal FHA, here's what is required by law of you folks in Dalton Township, which I think is, that is more telling than the city council having to pay $100,000 or $500,000 or $1 million. You know why? The city council doesn't have a dog in that. They don't. Nothing comes out of their pocket. But if you make them go through the public embarrassment of having to go sit in front of somebody telling them, here's what the federal law requires of you buffoons, that's wonderful. You can't buy that.
So let's everyone give Jeff Van Treese a round of applause and thank you again, and we'll see you back in here at 3:15.